Rules and rights. Consider the following two statements. 1. In English law, I have the right to walk myself and my dog around the edges of the farmer's field where the public footpath is marked, but I must not walk across the middle of the field and destroy the crops. 2. At the entrance to the field, there is a sign which says no horse riding. Imagine I come to you and ask for your advice about whether I'm allowed to ride a camel around the edges of the field. What is your response? The two statements I made are indicative of two different building blocks of law. Let's take the second statement first. The sign, no horse riding, is of course shorthand for a more detailed legal rule which will be set down in a local bylaw. According to H.L.A. Hart, a judge or anyone else trying to interpret that law should carry out the exercise of interpretation in two stages. The first stage is to identify whether the action I'm proposing to carry out is clearly prohibited by the rule. In Hart's terms, does my proposed action fall within the core of the rule? So, if I turned up with a Shire horse or a Shetland pony and asked if I could ride those around the field, the answer would be clearly no. The action is not clearly prohibited by the rule. Hart says the next stage is to consider whether the action falls within the penumbra, within the grey area where the rule, looking at its semantics, could be interpreted one way or the other. In that grey area, Hart says, the interpreter must reason by analogy from the core cases and may even have regard to the purpose for which the rule seems to be made. So if the purpose of the rule is to prevent destruction of the farmer's crops, we might reason that riding a donkey or camel or an elephant or cow even would be just as destructive, and therefore those actions are prohibited. In the case of a penal statute, we might adopt a stricter interpretation, but a common law rule banning horse riding might reasonably be interpreted by a judge as also banning the riding of any of animals. The other set of building blocks is rights. The definitive exposition of this approach to law was given by the American legal theorist Wesley Hohfeld in 1919. Hohfeld argued that when we talk about rights, we are using an umbrella term which actually describes four very different kinds of thing, four different types of legal advantage. So we can construct law using the building blocks of rules and the building blocks of rights. Before turning to Hohfeld's analysis of rights, let's have a deeper look at how Hart analysed rules. I've already told you how Hart says that rules should be interpreted, but Hart thought that all legal systems consist of two kinds or two levels of rules. One kind of rule, which Hart somewhat confusingly calls primary rules, tell subjects what they can do and what they cannot do. The other kind of rules, which Hart calls secondary rules, identify the persons and the procedures by which primary rules can be properly issued. Hart thought that holding the entire system together was what he called a rule of recognition. The rule of recognition is the rule which identifies the sources of law, the people and procedures who can issue the primary rules. The rule of recognition is, in most legal systems, incredibly complex, or it is, to put it bluntly, simply a symbol or a fiction. So Hart thinks that we have primary rules and secondary rules in a legal system, and he thinks that when you interpret them according to the semantics within the core meaning, and then you interpret them with some element of purpose in mind when you're dealing with the penumbra. Turning then to Hohfeld. As I said, Wesley Hohfeld thinks that when we use the term right, we are in fact describing one of four different kinds of legal advantage. The first kind of thing, the first kind of legal advantage that Hohfeld identifies, he calls a privilege. I'm going to call it a liberty right. We might also perhaps call some of these negative freedoms. But a classic example of a privilege or a liberty right would be the right to freedom of worship or the right to freedom of speech. The second kind of right is a claim right. These are positive claims, such as the right to an education or the right not to be abused. Now, these two kinds of right are quite easy to understand. Liberty rights and claim rights are examples of what Hart calls primary rules, i.e., they are rules which require that people act in certain ways or do not act in certain ways. The other two kinds of right Hohfeld identifies are more difficult. or at least I find them more difficult to understand. Because the other two kinds of rights relate to what Hart calls secondary rules. They specify how agents can introduce and change others' liberty rights and claim rights, or how agents are prohibited from asserting their liberty rights and claim rights. So, Hohfeld's third kind of right are powers. For example, the right of the federal government to demand taxes is really the power that the federal government has to impose taxes. And Hohfeld's fourth kind of right are immunities. For example, the immunity which members of the British Parliament enjoy from being prosecuted or sued for anything they say in the debating chamber. Another example would be the immunities which American citizens enjoy from being ordered to kneel before the cross, to prostrate themselves in prayer, or to give the Nazi salute. Now, Hohfeld not only sets out these four kinds of right, but he also says that each of them has a corresponding obligation. Or, to put it another way, if person A enjoys one of these rights, then person B necessarily owes the corresponding obligation. This claim is known as the correlativity principle. It's the claim that rights and obligations go together like two sides of a coin. So, if we go through our examples again, if I have the right to freedom of worship, then you have no right to prevent me from worshipping or to force me to worship in a way that I do not choose. If I have a right to an education, then someone has a duty to provide me with that education. If the federal government has the power to impose taxes, then those subject to that power have a liability to pay federal taxes. And if a parliamentarian is immune from prosecution for anything said in the debating chamber, then the prosecuting authorities are disabled from bringing a prosecution in respect of such statements. To sum up, liberty rights correlate to no rights, claim rights correlate to duties, powers correlate to liabilities, and immunities correlate to disabilities. Now, there are interesting and important questions about whether claim rights have priority over duties or vice versa. Or you'll have to make up your mind about those questions as your studies continue. Now, in fact, the explanation of the different kinds of rights I have given is too simplistic. Rights such as the right to private property are, in fact, bundles of the different types of rights. And Hohfeld's claim is that if we distinguish the privilege, the claim, the power, and the immunity aspects of these rights, we will be able to see better where the limits of rights lie. Although there are challenges in applying Hohfeld's scheme in practice, it has the clear advantage that Hohfeld conceptualized rights in terms of relationships. He highlights that when someone has a right, that is always a right either against some other person or persons in particular, or against the world at large. Rights are not things which belong to me as if they were items of property. They are, as Nicholas Walterstorff claims, normative aspects of our social relations. So to return to the example I gave at the beginning, in terms of the sign "No Horse Riding," that sign exists because my local council has the power to put up such signs and enforce the prohibitions contained in them. The sign then helps define my liberty right to proceed around the farmer's field and defines the extent of the farmer's duty to let me.